Hi and welcome to the show. Most people don't know what to do or expect when faced with a legal dispute, be that in labor, matrimonial, debt counseling, property law, or more. We aim to give our viewers a broader understanding of the law in South Africa to make sure the vulnerable are not taken advantage of. In this show, we address specific questions by you, the viewers, via our WhatsApp and our email platform. So don't forget to send in your questions to the WhatsApp number and the email address that will be provided at the end of the show. I'm your host, Fazloodien Abrahams, and you're watching the Fazlaw Show on Cape Town TV. According to Business Tech article and the recent job losses, debtors are fighting a battle to maintain their lifestyles. With those earning between 10,000 and 20,000 Rand, consumers consistently need to spend around 60% of their take-home pay to service their debt before going for debt counseling. With interest rates on the rise and now all low salary increases, the result is that debtors now find themselves in dire straits. According to a Sunday Times article, demand for debt counseling in the fourth quarter of 2021 rose by 18% compared to the same period the previous year. This trend intensified in the first month of 2020, with inquiries increasing by a staggering 32% compared to January 2021. With more consumers now proactively seeking help to manage their debt, we have to ask, what is debt counseling and what does it really help the consumers? Is there hope or not? With me today, I have our special guest and expert, Mogamat Thariq Orrie, an attorney with a path of regulatory compliance, litigation, residential and commercial property management, conveyancing, commercial drafting, vetting, and is a lecturer at a college in the CBD. Thariq is a debt counseling specialist with expertise in civil litigation, property management, and debt review applications. Thariq, thank you for being on the show.
Pleasure.
So Thariq, today basically what we'll be doing is making sure that the viewers' questions are answered. But before we go there, I need to obviously address just making sure the foundation is strong. And there are a couple of questions that I need to pose to you. So with the banks making up more than 2/3 of the debt, that being in a home and the vehicle, the average spender take very little home and they are left with very little. So how do they still manage to live a good life?
From what I can see is consumers are not managing, be it the lower class, the middle class, as well as the higher class. They are not managing in the sense that the credit agreements or the credit installments is so high that they're not able to have sufficient money available to basically live a good life or satisfy the essential living expenses. And that is the problem that we have with consumers.
Okay. So debtors lose their job every day. And the result is that they cannot afford to pay their debt. Lo and behold, you find that a debtor receives in the post what you call a Section 29 letter. What is a Section 129 letter?
Well, a Section 29 letter is basically a notification that is provided or forwarded to the consumer. And I use consumer and debtor interchangeably to notify them that they are in arrears with their credit agreements and the possible solutions to remedy that.
So obviously with that comes a condition that, so in other words, the notice in effect says you are now over indebted or you're struggling to pay your debt and you have this right and that right. And one of those rights are to go to your debt counselor. Am I correct?
Correct. So it will essentially just notify you that you are in arrears with your installment.
Right, okay.
And what the arrears amount is. And then it gives you the option to either go see a debt counselor, a credit ombudsman, or an alternative dispute resolution agent. That is options available.
Sure. With regards to debt counseling, it says that the interest rate can be reduced. How does that work?
So there was a recent judgment, Nedbank versus Jones, which provided that the courts are not allowed to refuse granting a reduced interest rate where it is accepted by credit providers. So essentially, if it is accepted by credit providers, the interest rate can be reduced.
Excellent. A creditor hand over debtor to the debt collector. When can the debt collector call the debtor? I believe that there are certain days they can't call you. Yeah. When is that?
They are usually not allowed to call you on a Sunday.
Okay.
However, usually they will call you once you miss your installment. That is usually the credit provider. And if a matter is handed over to debt collectors, usually after a month or so, they will start calling you.
All right. And I want to focus on some of the questions that is important, just to lay the foundation, right? So what is a credit agreement?
Credit agreement is an agreement between a credit provider, which is registered in terms of the National Credit Act, as well as the consumer, whereby they will supply you with either goods or services, such as a vehicle or loan.
Okay. And then what could happen if a debtor fails to pay their account?
Well, if they fail to pay the account, the legal proceedings will be instituted by the Section 129 letter, as we mentioned earlier. If nothing is resolved with the 129 letter, they will issue a summons, and they will basically obtain a judgment on the consumer and repossess his vehicle, if it's a vehicle, or the property if it's a mortgage agreement.
Okay. So what happens, we spoke about the Section 129 letter, what happens if the creditor issues a summons without issuing the 129 letter?
There are legal repercussions for issuing a summons without the required 129 letter. The courts will usually not grant the judgment and refer the matter back to the attorney to firstly issue the 129 letter before issuing the summons. So in other words, the summons will be issued prematurely.
So if a debtor sees a summons without the 129 letter, it would say Section 129, and if there's no letter attached, then that's let's say a reason for the judge or the magistrate not to grant the judgment.
Correct, yes.
Excellent. Okay. That brings us to the end of the first segment. We will go now for an ad break. Keep watching for more answers to your question. I'm your host, Fazloodien Abrahams. Thank you. Welcome back to the show. In the first segment, we looked at the statistics of debt counseling in South Africa. An article from the Business Tech, Sunday Times Live, and we got to know our guest legal expert, attorney Mogamat Thariq Orrie. Then towards the end of the first segment, we had a short discussion on usual disputes and the legal ramifications when a debtor or creditor do not comply with the law. I'm your host, Fazloodien Abrahams, and you're watching The Fazlaw Show. I now would like to turn to the focus of the discussion onto the efficacy of the current law. I want to focus more particularly on what the law, or when the law was created, and whether there were any challenges over the years. Before we move over to the next segment, I would like our expert to explain just a few words that we mentioned. Thariq, the word efficacy. What does it mean to the layman, and how does it apply to the National Credit Act?
Well, it is the ability to produce the desired result in terms of the intention of the National Credit Act. And I feel that the National Credit Act is effective in a sense that the legislation was put in place. There is procedures in terms of its regulations, and if followed correctly, it is quite efficient.
Okay. And with regards to debt counseling, which laws specifically apply to debt counseling besides the National Credit Act? Are there any other laws, and when were they written?
It's basically just the National Credit Act, which repealed the previous UJ Act, the Credit Agreements Act, and the Exemption Notices Act. The other act that applies currently would be the Consumer Protection Act, but not specifically to debt counseling, more from a consumer's rights point of view.
Okay. And then are there provisions contained in the current law, which would be the basis for debt counseling, the National Credit Act? Are these provisions still applicable? Do you think that they need to change a bit in order to be more effective?
The provisions in the National Credit Act are still applicable. However, throughout the years, there has been certain amendments to tighten up the industry in terms of the roles of debt counselors, the credit industry, where reckless credit is concerned. And there has been changes as well. In 2014, there was a National Credit Act Amendment Act as well.
Okay. Right. Now, I'd like to focus on a couple of questions that were sent in by the viewers. It's fairly relevant questions, and I think it's very important that we get to answer them. The first question is, how long does an application for debt review take?
From start to finish, from when the consumer applies for debt review, he fills out what is called the Form 16. That's the application for debt review. The debt counselor will normally take about a month to finalize all its internal procedures. And then it has to go either to the tribunal court or the magistrate's court, which can take up to usually around 3 to 4 months.
Okay. And then just to give us a better understanding, what is debt review? What does it mean?
Debt review is basically a mechanism in terms of the National Credit Act that's put into place to relieve consumers that are struggling with their debt.
Okay, excellent. How long does the debt review last? Once you've successfully applied, you got your order, how long does that process last for you?
Depending on the credit agreement, usually credit terms will get extended to about 5 years. So that is when it will last up until 5 years. Once it is finalized, the 5-year period has lapsed, the credit provider will, or the consumer will exit debt review.
Okay. And then will going under debt review prevent my car from being repossessed?
Yes, it will, provided that the procedures are followed in terms of the National Credit Act.
Okay. So are we saying that the car won't be repossessed if there's no summons issued before you apply for debt review? Or do you apply for debt review, get your order, and then that protects your car? But what if you had a judgment before then on the car?
Okay, let me just break that up. So once the consumer applies for debt review and there's no summons that has been issued, the consumer is basically protected from his car being repossessed.
Okay.
And then obviously the legal process of the debt review runs and the court order is obtained, and the credit provider and the consumer is obliged to stick to the terms of the court order.
Okay. What are the advantages of going under debt review?
The advantages of going under debt review are that the credit providers will stop harassing the consumer. The consumer will obtain financial relief in the sense that he will have a certain period to pay off his debt. Also shows the credit provider that the consumer is responsible. And it offers, the main reason is it offers protection for the consumer from assets being repossessed.
Great. Another question that was sent in, what are the disadvantages of going under debt review?
The disadvantage of going under debt review is once you're under debt review, you're not allowed to enter into any further credit agreements. It also might affect job applications. Where you apply to the financial industry, and a specific requirement of the job is where obviously you need to have a sound financial background. The other disadvantage of debt review is if it's not done correctly in terms of its procedures, the creditor might still be able to take legal action against you.
Okay. So it's important to get the right lawyer, acting for you.
The right debt counselor and the right lawyer.
Excellent. And then the next question is, can I get a loan while being under debt review?
So no, that is prohibited in terms of the National Credit Act to obtain a loan. It's regarded as reckless credit if a credit provider should provide you with a loan.
So the creditor, when you apply for a loan, the creditor will then do a credit check. Correct. He will then see that you are under debt review, and that prevents him from granting your loan. Correct. If he do that, nonetheless, ignoring the status of you being under debt review, that would be considered as reckless lending.
Correct.
And if he then sues you for it, he won't succeed in the court of law because it falls under reckless lending. Am I correct?
Yes, he won't succeed in the court of law. If you meet all the requirements of reckless lending, then obviously your debt might be scrapped. depending on the court.
Okay. Another question. I no longer wish to be under debt review, and I can't get hold of my counselor. What do I do?
If you can't get hold of your debt counselor, then you may contact the National Credit Regulator. So they will have a list of all registered debt counselors, and they will try to or attempt to contact the debt counselor on your behalf. If they're not able to, they will look for another debt counselor to assist you.
Okay. Another question that was asked by our viewers is, will going under debt review prevent my house from being repossessed?
Yes, so the same as whatever asset you have when you apply for debt review, it will prevent your house from being repossessed, provided that the correct procedures are followed by your debt counselor as well as your attorney.
So how does one know really the correct procedures? For example, if you now receive a summons from a creditor whilst you're under debt review, then you know that creditor is trying his luck, or they're trying to circumvent the whole process, and protection provided to you as a debtor. Am I correct?
Yes, so
You then you take that summons and take it to your debt counselor or your attorney who dealt with the application, and he will deal with it for you.
they will deal with it for you, yes.
Awesome. Okay, right. Let's see. Okay, that brings us to the end of the second segment. Keep watching for more answers to your questions. I'm your host, Fazloodien Abrahams, and you're watching The Fazlaw Show. Welcome back to the show. In the second segment, we started with a recap on the first segment. We discussed the efficacy of the current laws pertaining to the National Credit Act and if those laws need to change. Towards the end of the second segment, we had a question and answer session with our guest legal expert, attorney Mogamat Thariq Orrie. I'm your host, Fazloodien Abrahams, and you're watching The Fazlaw Show on Cape Town TV. Thariq, we're back to the questions with regards to the viewers, right? So they've sent in a couple of questions, and the first one that I need answered is, how does being under debt review affect me applying for a job in the future?
Well, it depends which industry you're in. So if you're in a job that requires, or in the financial industry, it will affect that in the sense that you won't obtain a job in that industry, but however, if you're not in the financial industry, you can obtain a job.
So we're talking in the banking industry, for example, if you apply for a job in the bank as a, let's say, what do you call this, insurance consultant, in the loans department and so forth, right?
Correct, yes.
Okay. Another question, does being under debt review affect my insurance policies?
No, it does not affect your insurance policies. That is regulated by different legislation.
Okay. Right. So I can have a policy on my life, my home, my car, just on
Correct.
that one. If you have your loan repayments for your home or for your car, it usually comes with the installment plus a policy like an insurance policy in the event of death or disability, and that would cover that. Right. Going under debt review, does that include that policy repayments as well, or installments?
The installments will be included under your restructured payment plan that is provided by the debt counselor. However, the debt counselor is not authorized to advise the consumer on any insurance policies. The consumer would obviously have to speak to his financial advisor in that regard.
Okay, thank you. Another question here, what is the cost involved to be placed under debt review?
So usually the debt counselor would have a fee, and the attorney would have a fee as well for the legal costs of doing the application in the magistrate's court. It's usually up to the installment of the credit providers, or a maximum of 10,000 rand.
Okay. Another one here, will the employer know that I'm under debt review? So you're
Not
currently
necessarily.
working, you're employed, you apply for debt review, that notice that goes to the creditors, would that have to go to the employer as well?
No, there is no notice that has to go to the employer, and the employer will not necessarily be notified of debt review unless you specifically, as the employee, tells them about it.
But is there an obligation on you to notify the employer or not?
No, there's no obligation on you to notify your employer.
And if the employer should ask a question to you, are you obligated to then say, or do you still have an option by saying no, or you rather do not wish to disclose that information to the employer? Can he then take further steps when it comes to that?
You you don't have to divulge that information if it's not in terms of your contract of employment.
Okay. Now the question that was asked by the viewers is, I'm under debt review and my creditor is still calling me for payments. What do I do?
We have various options. So you can contact the National Credit Regulator, which regulates credit providers. You can contact the Credit Ombudsman, as well as your debt counselor. Your debt counselor will forward certain notices to your credit providers to notify them that you are under debt review, and that they should contact the debt counselor if need be, for any reason.
So if anyone calls you, send you a letter and say, I'm a creditor, I want to know when you're paying or whatever, you just say, I don't speak to you, I'll speak to my lawyer. Or don't speak to me, speak to my lawyer. Correct?
Correct. Or they'll say, speak to my debt counselor if they're under debt review.
Yeah, perfect. So there's a difference. The attorney dealing with your debt review application and your debt counselor are two different people.
They are two different people.
Okay.
The Act doesn't specifically prohibit an attorney being a debt counselor, but usually they're two different people. The debt counsel will handle issues like the notification to the credit providers as well as the negotiations.
Okay. Next one. What happens if I'm retrenched while under debt review?
If you are retrenched under debt review, you need to notify your debt counselor. He will then send out the requisite notification to your credit providers. It's called a 17.3. That basically gives the consumer up to 3 months where he has had a financial change in his circumstances to find another job. So they can't take any further legal action within that specified time period.
Okay. It brings me to another question. I know that when you are retrenched and you have a particular type of insurance like a mortgage protection plan, also on your home loan or even your car repayments, the insurance kicks in and they will then continue paying your installment until you are employed to a maximum of 12 months. If you go under debt review, is that still enforceable?
If that is still enforceable, yes. So your insurance policy will kick in, they will pay you installments. However, your installment would have to be the same amount as the installment that the debt counselor negotiated on your behalf.
I understand. Okay. Next question is, can I still go under debt review if I have a judgment against my name?
Yes, you can go under debt review. So if you have various credit providers, you have a judgment, for example, on your vehicle, that judgment will basically be under your expenses part on your debt review, but all other credit providers will be under debt review, if you know what I mean.
Yeah. And then, can I be blacklisted while still under debt review?
No. So if there's a judgment on your name, you're already blacklisted in terms of that judgment.
Yeah.
However, whatever credit provider is under your debt review application, you will not be able to be blacklisted in terms of that credit provider.
Excellent. And then the last question, what happens after debt review?
So once you've completed the debt review program, normally about 5 years, you will obtain paid-up letters from your credit providers. Once you obtain the paid-up letters from your credit providers, you will basically be issued with a clearance certificate from your debt counselor. Your debt counselor will then update the credit bureaus, will notify your credit providers, and then the credit bureaus has about 21 days to clear your credit status.
Okay. All right. So after that whole process, you can now confidently say I have been, not for lack of the better word, rehabilitated. I am now, my debt is all paid up. I'm released from being under debt review, and I can then start life as normal and maybe apply for another credit agreement or learn from your lessons in the past and not make too much debt. Correct?
Correct, yes. So the consumer will basically be able to start afresh. We were able to enter into further credit agreements, or, as you say, not make any further credit.
Right. Okay, thank you, Tariq. That brings us to the end of the question and answer session for the show. I really appreciate you being on the show. You've been an excellent guest and even a better expert. And we're looking forward to having you again soon.
A pleasure being here.
Okay. That brings us to the end of the show. However, before you leave, don't forget to send us your questions to the email address being info@fazlaw.co.za. That's info@fazlaw.co.za, or the WhatsApp number on 082 495 8989. That's 082 495 8989. In our next episode, we discuss the Muslim marriages versus civil marriages and the current law. So please follow us on YouTube, Facebook, Twitter, and Instagram. I'm your host, Fazloodien Abrahams, and thank you for watching The Fazlaw Show.